Good morning, everyone. Welcome to our administrative public hearing. We have speakers on a number of items. The first one is item number 2 on our agenda, which is proposed amendment of Rule 16 and the proposed addition of Rule 20 of the rules concerning the State Bar of Michigan that would clarify the process of investigation of the unauthorized practice of law claims and outline procedures for the Client Protection Fund. We have one speaker who has been authorized on this item, and it is Attorney Alicia Chandler on behalf of the State Bar of Michigan. Ms. Chandler, you will have 3 minutes. You can see your timer there, and we might have questions for you. Thank you for being here. You may proceed.
Thank you. Good morning, Chief Justice and Justices of the Supreme Court. My name is Alicia Chandler. I am the Professional Responsibility Programs Director for the State Bar of Michigan. One of my responsibilities for the State Bar is leading the Client Protection Fund and managing its investigations. So I'd like to comment today on the subpoena power and immunity provisions in our proposal concerning State Bar Rules 16 and 20. Regarding subpoena power, to effectively protect the public, the State Bar of Michigan's Unauthorized Practice of Law and Client Protection Fund need the ability to issue subpoenas to support our investigation of claims. Without this authority, the Unauthorized Practice of Law staff is forced to rely upon cooperation from witnesses and parties to obtain any documents to corroborate allegations or defenses. This becomes an issue when investigating businesses with employees engaged in the unauthorized practice of law. Almost universally, the business alleges the non-licensed attorney or non-licensed individual is not an employee, but is an independent contractor, and the business has no knowledge that the individual isn't licensed. In this situation, staff is forced to rely upon the cooperation of the business or the individual suspected of engaging in UPL to provide relevant agreements that will help determine those relationships between the employer and the employee. So in circumstances like these, where people with relevant documents have absolutely no interest in cooperating with the investigation, the State Bar needs to have the power to subpoena the documents to adequately investigate the claims and determine, is the business really a proper defendant in that matter? Similarly, in the Client Protection Fund world, in our investigations, in many cases, we have to rely on the Attorney Grievance Commission to obtain any documents that we may need because we don't have the authority to do that. But oftentimes their investigation is limited and we need records outside of that time frame. For example, in a recent case, one attorney was disbarred for a federal conviction completely unrelated to the misappropriation. And so the AGC's investigation was limited to that conviction, did not include all of the records that we could have used. And those records would have supported payments to the attorney, which would allow appropriate reimbursement to the claimants. In another situation, the attorney had long-term widespread theft, but the Attorney Grievance Commission only had to investigate a short time frame. So we didn't have records from before or after when they were investigating those claims. Additionally, when the attorney accused of misappropriating the funds is deceased, the attorney grievance has no authority unless a receivership is established to investigate the respondent. So we have no ability to obtain those vital records to fully investigate our claims.
Thank you, Ms. Chandler. Let me see if anybody has any questions for you. If any justice has a question, you can just unmute and ask. I'm not going to go one by one. I don't see any, so thank you very much for being here. We appreciate your contributions.
Thank you.
We had a speaker endorsed for item number 5, but I do not see Mr. Lawrence in the Zoom room. So I am going to move to item number 6, which is the proposed amendment to MCR 2.108 that would provide a time frame for a responsive pleading when a motion for a more definite statement is denied. And we have Attorney Garrett Haddon endorsed to speak on this item. Mr. Haddon, good morning. You may proceed.
Good morning. Good morning, Chief Justice McCormick and the other justices of the court. When I read this proposed amendment, I was very happy to see this change, and for 2 main reasons. First, My name is Garrett Haddon. I currently practice in transactional work as a business attorney at Bodman PLC in private practice. But previously, I have some litigation experience. And when I was working in litigation, I actually had an instance where MCR 2.108 came into play. And I asked a partner shareholder whether or not this particular rule applied to MCR 2.115 because it did not explicitly mention it, but it did explicitly mention 2.116. And so my response from him was it did have a degree of ambiguity. And basically, the amendment here clarifies the rule, and it allows for attorneys that do practice in this area to be able to have a definite, well-stated rule that they can rely upon when looking for these types of procedural matters, right? So that's one point. But the other is a very much more pragmatic thing that I've seen where I've had individuals approach me with instances where a lot of domestic legal matters are taking place where maybe one individual is given appointed legal counsel and the other is not. And so another reason why this amendment is a step in the right direction for the Michigan court rules is because it makes it easier to navigate the court rules for someone who may not have appointed counsel. And of course, it's best if someone has an attorney to represent them. But if they do not, then having the Michigan court rules easier to navigate serves the underlying purpose of judicial efficiency. And so a lot of times we see timing coming into play in the pleadings where an individual may be served with pleadings, they receive paper in the mail, and now they have a hearing in 7 days or 14 days. And so while they're going through those pleadings, if they want to ask for a more definitive statement, this amendment would make it clear and explicit the time frame that they would then have if that request was denied before they would have to in turn respond with their initial response to the pleadings.
Thank you, Mr. Haddon. Let me see if anybody has any questions for you. Any justice who has one can just unmute and ask. Okay, thank you very much for being here and for your contributions. We appreciate it.
Thank you.
I believe we have one more person who is entering from the waiting room, and I think here by phone. And is it Attorney Frank Lawrence?
That person is now gone, so
Oh.
he's no longer in the waiting room.
Okay, so we are then concluded. This was a quick administrative public hearing. We want to thank our speakers, and we are adjourned for today. Thank you.
I'm sorry, Chief Justice, I do see he is in now. I will need to unmute him.
Okay, let's do that and see if it's
Sorry
Mr.
about that. I have asked to unmute him. He has to unmute himself.
There we go. Is this Mr. Lawrence on the phone? The person who's just been admitted to the public hearing, can you please identify yourself?
Oh, Chief Justice, it's Chris Murray. I'm just here in case there was any questions with Mary Beth.
Thank you, Chief Judge Murray. We thought you might be our missing speaker because we had no identification, but because we don't have a speaker on item number 5, we appreciate you and Mary Beth both being here, but we will adjourn for today. We know where to find you, so we know how to ask questions anytime we want. So thank you.
All right, have a great day.
Okay, take care,
All right,
everyone.
bye-bye.
We are now formally adjourned.